I will now invite Mr. Raj Shekhar, founder of JurisOpen, to begin with the second session.
First of all, I would like to thank Professor Pandey for that very eloquent speech. I'm sure you must have learned a lot in this process. One thing I can promise you all is that it is going to be the best investment of your time at law school here. You are going to do things you never did before. And no matter how boring it may sound at the outset, legal research and writing, it is actually very interesting if you have the right guidance and the mentorship. So first of all, let's lighten the mood with an interesting story. Can any one of you point me out that the map here represents which demographic? Any one of you? You have to think.
It's basically all the states wherein the Indian laws are applicable. That is except Jammu.
So it's okay. So it's the sovereign, socialist, secular, democratic Republic of India. It's actually free justice, the last time I checked. Now what happens in this Republic of Free Justice? You obviously have free legal services. And these free legal services, first of all, include, to start off, all the attorneys are public employees of the company. So you don't have to pay an attorney services fee, just to start off with. Then, besides that, you have the court filing charges, which is equal to nil. There are no court filing charges. And if that's not enough, the Republic of Free Justice also has free law repository facilities, the state-of-the-art infrastructure where you can all find all the laws to your requirement in that repository. Now, all these laws are obviously promulgated by the Republic of Free Justice and are contained in what are called as white papers. These are called white papers. Now these white papers, there's a catch. To correctly locate and understand the white papers, you need to reference what are known as green papers. The catch is that the green papers are owned and managed exclusively by the Read Elsewhere Corporation. So if you had this thought that the petition for free justice would only require you to reference the necessary laws suiting your requirement, you might be mistaken, because they, apart from requiring you to reference white papers, they also want you to cite the requisite green papers. So what happened? The public protested. This is unjust. You said that law is free, justice is free. But if I have to buy my understanding of the law from a private corporation, then obviously this is not free. But the president appeared and he said, well, the laws are only public. How many of you here agree with what he claims? You can just raise your hand if you agree with him. The laws are only public. Okay. Why do you think that? If you have to raise your hand if you think you agree with the claim, are the laws really public? So the president said that the laws are only public. Do you agree with what is happening in the Republic of Free Justice here?
Yes, it's rather the channels that are being charged, and it's rather the channels that people have paid for and not the basic reason.
Fine, sure. What happened after that? Now this is fictional, of course. By that you must have gathered by now. But this is fictional because obviously attorneys do not come free in the free world, and no real nation state can actually afford zero court filing charges. Even so, there's something about the Republic of Free Justice which yet remains true, and for that reason the Republic of Justice is equal to India or any other nation state for that matter, and this is a global problem. So white papers, for the first years who are here, I must reference these are primary legal authorities. For those of you who don't know, by some chance, green papers are secondary legal authorities. Now what are they? Primary authorities are your constitutions, statutes, case laws, government notifications, circuits, etc. And your secondary authorities have the function of explaining and exemplifying the law. So these include research articles, treatises, legislative commentaries, case notes, etc. Primary authorities. Now the thing is that primary authorities are public. But when it comes to secondary authorities, they are almost proprietary. Means you have to buy your understanding of the law from a Westlaw, LexisNexis, SCC Online, and to me that's sick. To know the laws in primary authorities in order to claim your rights and defend your liabilities in court, you need to be able to afford explanation to the laws in secondary authorities. Since primary and secondary are not the same, which most of us mean it to be sometimes in our speech, is the law public? Do you guys agree with this? Like, is the law public? Can you say yes? Okay, let's say yes. Is the law really public? Now you have to say no. Because if you can't understand the law, it's not accessible to you. That's the proposition. This is the proposition which has framed the mission objectives of JurisOpen. Now we have talked enough about the problem. I want to talk about the solution now. What's the solution? Well, there are professors like K.A. Pandey and many erudite scholars who can write numerous articles for open access. There are law students like yourself who can write numerous blogs for open access. But the thing is, why don't you do it? Why don't you actually go out there, pick up a book and start writing? And why you tend to have this tendency, no, I want to move, I'm at a law school, I must know how to make my argument in court. But most of us tend to forget that legal research is an essential lawyering skill. If you can't research your case laws the correct way, if you can't frame your arguments well in a petition, it will be rejected in the Supreme Court of India. Let alone your argumentation skills, they won't even be entertained. Why you go for debates? I mean, they are a great sport. You should do it. But what happens when we come to legal research? We get bored. Because we lack guidance and mentorship. I totally agree with you. So what's the solution? Publish openly. Recently, I had the opportunity to interview Professor Shamnad Bashir, who is one of the widely recognized experts of intellectual property law. He sat on the panel of the World Economic Forum in 2012, if I'm not wrong. And he's also the founder of the Spicy IT blog, which is the most read and cited intellectual property blogs in the world. Now, he claimed that we must foster effective quality control mechanisms so that open access publications comprise data and scholarship of the highest quality and integrity. That's critical to the academic endeavor. Now, why he makes this claim? If there are free law websites we often tend to download our projects from, what's wrong with those websites? The problem is that free alternative facilities to Westlaw, LexisNexis, etc., they are not authentic and reliable. So lack of citable or authoritative content, which Sir rightly pointed out. Now, when I was reading economics in my first year, I was very fascinated by this proposition that people respond to incentives. Now, this proposition was actually initially raised. Few people know about this. Gregory Mankiw, he was the chief financial advisor in the Obama administration, and he used to say this again and again, that people respond to incentives. You have yet not been incentivized enough to do legal research and writing at law school. That's the problem, that's the modality through which JurisOpen seeks to address the abysmal conditions of legal literacy in our country and all over the world. How? So, high impact paid journals. Sir referred to the Harvard Law Review. It's a high impact, but you have to pay in order to read the articles that it contains. What happens with open access journals? Sir referred to the problem of predatory publishing. That's a valid problem, and I totally agree with him. But what's the solution? What can be the alternative? How do we create an alternative to a high impact paid journal? And if we don't, access to justice at every point will be compromised upon. How do we solve this problem? It's a big problem. The thing is, there is no added incentive to publish openly. So where to publish? When you are choosing a law review, where you want to get your articles published, you refer to the prestige of the journal, rightfully so, but you should also refer to the impact factor of that journal, meaning how likely is your paper to get cited in other publications from the reader who reads it for his own research and discourses. That is the measure of the impact factor. Now, besides the impact factor, if you're a law student, you want to get published to earn scholarly credit. In some schools, I don't know in India, but in abroad, you can miss a few classes if you write a few research papers. Through that, you can earn your grades back. That's scholarly credit. If you are a professor and if you earn scholarly credit, you can possibly get a tenure, means a promotion. That's scholarly credit. High impact journals so far have been excellently managed to gather enough scholarly credit, but a majority of them are paid. I mean, you can't read them if you can't afford them. Open access journals, I don't know what is the reason, they can't afford you scholarly credit. There is no scholarly credit. Now, what is the scholarly credit? Yeah. You have any questions? Sorry. Scholarly credit. Now, it looks like a very abstract term, right? Scholarly credit. Now, this is not a term that I coined. Scholarly credit was traditionally, it goes back to the dates when scholarship was generated for public reading. It was traditionally granted by public or private institutions for higher learning or prestigious publishing conglomerates. You can take the example of the most expensive publishing conglomerate, which is the Reed Elsevier. So there I had Reed Elsewhere Corporation, so the pun was intended. So it is to research which in their opinion was a valuable addition to the literature on any subject. So it was an institutional thing. If the Harvard Law Review says that your research is valuable to our readers, it will publish your research, or it can say, I don't like your paper, and you will have no idea what to do next. So it was very vague. How papers are shortlisted, how papers are not published, it's very vague. But it thrives on scholarly credit. The driving incentive is scholarly credit. So what I thought about, like when I initially started off with JurisOpen, I thought to make it more democratic, the process of scholarly publishing, to make it more open and democratic. So what did I do? I thought that can scholarly credit be granted by an individual subject expert to research which in his or her opinion is a valuable addition to the literature, especially in the context of law. And then JurisOpen was born. Here what we do is we incentivize you to do research for us, and in turn you get scholarly credit. You get published as well as you get scholarly accreditation for the research that you do for us. The format is that you as a researcher submit your research in any standard publication format. It can be a research article, it can be a book, it can be a case, commentary, whatever you can write. After that, what is the other incentive? We have a specialist editor whose job is to do preliminary review of the research in accordance with the JurisOpen Publishing and Sharing Standards. Now, what are the JPSS? It means that your work should be original, it should not be plagiarized, it should have content that is relevant to the subject of law, and third, the work should have minimum authority in it, meaning the citations should be sufficient and reliable. Once the editor checks your paper in accordance with the JPSS, the JurisOpen Publishing and Sharing Standards, he agrees to give preliminary review or feedback on your work, on your research. This will enable you to improve your research contribution and also learn in that process by actually doing it. So it's theory and practice both. I'm not a great believer in theory. You learn more when you actually do it. As Sir said, you have to be on the driving seat. Right? Then we have the advisor. We have 8 advisors at the moment, and we will be inducting more. These are subject specialists, subject experts. What's their job? Once your paper goes from the editor to the advisor has the same job. The only thing is that his standards are stricter, and he also has the prerogative of giving you an expert review and authenticating your research, and in that process you gain scholarly credit. So he credits the research with scholarly value. That's the incentive that I'm trying to offer you guys here. So scholarly accreditation is the process through which we intend to create authoritative, citable content online. Now, one of our prime modalities of engaging with the young scholars and early career researchers is, now, if I ask like any of you, I mean, nobody's raising their hands, but if I ask like any one of you, what is the problem when you start out with legal research? People who might have made an attempt in the past, I think you will agree that you have no idea from where to start, right? Most people, I mean, I have spoken to several dozen students, and they say that Google search is their first step in the legal research process. I mean, that's totally okay. You can start out with that. But then you should know what are the authentic and reliable sources from where you should check the research, what you have been able to do so far. Now, through this program, we actually intend to offer undergraduate students a publishing opportunity through which they can get published on our platform, and their publication will be recognized by our advisors who are recognized names in their subject areas, and this will create authoritative legal scholarship under expert guidance and mentorship. You have, now how we do this? Since you do not know where to start from, what to research on, we give you a research roadmap. This research roadmap essentially gives you the context and the objective of your research, and you have a way out. Okay, so this is the scope and objective of the research that I want to do, and there's also a list of suggested readings from where you can start out your research. That's what is the research roadmap. And after you submit as a first draft of the research contribution that you have been able to create through the research roadmap, we have the experts whose job is to give you expert feedback. So there is no specialist kind of an editor. You can say like we have a few executive editors in our team, but their job is not to do this. You will be directly under expert guidance and supervision. They will guide you directly through mail. So all the feedback that you will receive should enable you to improve your research contribution, get published on an open access platform with scholarly accreditation. So who are on the JurisOpen Research Advisory Group, like who we are, who are on our team? We have Professor Malcolm A. Clark, Professor Emeritus of Commercial Contract Law, Cambridge, Mr. Ajay Rab, he is partner at Rab & Rab Associates. Most of us, I think, know him. Then we have obviously Professor K. A. Pandey and Suhas Sagar. He's lecturer in tax at the Hague University of Applied Sciences. Then we also have Dr. Gargi Chakrabarti. She is the authority on intellectual property law in India. She is the MHRD IPR chair in India. There are only 18 institutions in India which have the prerogative of engaging in research in the domain of intellectual property rights and furthering research in that area. Then we have obviously Dr. Devasis Puddar, who has written extensively in the field of human rights law and public international law. We have more, but now I just want to proceed to the last part of presentation. I mean, you have been very patient, I must say, because the exams are going to commence 2 days from now, and so I won't take more than 5 more minutes. Okay, so if I ask you, you will say, I can start my own blog, but then I can have a counter that if you will start your own blog and publish whatever you want, you will fail on seeking scholarly accreditation. Your career prospects might not be that bright, unless you are extraordinary. I mean, I can understand. There are special cases, but so what's the differentiating factor? If you submit your research to a Harvard Law Review, the problem is that most of these law reviews, assuming that they do a blind peer review, means they do not know your name and your institution, right? So they have a team of editors who will read your research and mark it based on various criteria, and if it qualifies, they will go ahead and publish it with a few, like, subject to their editorial requirements. That is assuming they do a blind peer review. They don't know your age, your status, your country of origin, nothing. Most journals, even after that, are not interested in publishing student research. And why should they? You have just started out. What do you know about? How can you inform the public on a grave legal matter? How can you do that, possibly? I mean, unless of course you are gifted or very bright. I mean, I am not. So I am speaking from my perspective. I mean, I would need experts to guide me through this process, and I'm sure I will learn a lot. So this is something that I want for myself. I'm not just trying to sell you on this. I will use it too. These elite law journals are actually not interested in publishing your research. And the elite names in various subject areas, like professor and all these people don't have sufficient incentives to publish on an open access platform, even if they have a chance of creating a higher impact and recognition for their work. Why is that? Because even they need scholarly credit for their tenures. They need promotion. These are names, prestigious publishing conglomerates like Reed Elsevier, Springer Verlag, Wolters Kluwer. You need your name on that publication. You will do anything to get published in that law review. But that should not be the case. So what we are trying to do here is we are trying to make the scholarly publishing process more individual than institutional. Up until this point, these institutions were dominating the scholarly publishing process. It was the Harvard Law Review. It was Dr. Manohar Lohiya National Law Review blog. Why institutions? Why can't you and I create a platform and write for us? JurisOpen seeks to provide an opportunity to budding writers who have the knack for legal research and writing, and we want to facilitate that opportunity to you free of cost. We will not charge you anything for the research roadmap. We will not charge you anything for the expert feedback. You will have complete autonomy over your paper, and even after your paper is published on our platform, you will retain the rights to share your work on other platforms as well. You own the copyright. Why publish? You will learn legal research and writing by actually doing it. Nobody is trying to do this right now. You will publish your research, as I said, with scholarly accreditation from subject experts and only advance your career prospects. Even law firms now have started to prefer students, graduating students who have more publications than moods, because that demonstrates your knowledge in the subject area in which you intend to practice, right? You will retain the rights to share your research on other publishing platforms. If you have your own blog and you want to go ahead and get your research published there, I won't stop you. JurisOpen is not interested in stopping you in sharing research. We stand for open access, we mean it, and we want you to share it with as many people as you can. Raise the impact of your work. We do not charge any publication fee or article processing charges, APCs. We will not charge you a dime for anything we do for you. And I think as responsible citizens of this country, it is our prerogative. We actually, we have been fortunate enough to land up in a national law university where we have a wonderful library with so many books, law reviews, journals. And it is our prerogative to inform the public on the laws which validate their very citizenry. In a democracy, you can't have a successful democracy if your public is misinformed or not informed. They have a stake in the parliament. That's the reason why we have civil society groups who share their opinions with parliamentarians on various socio-legal issues and so on and so forth. Why? That's participative democracy. And a large part of India still can't read and write. We together have to solve this problem. This is not just about JurisOpen or me or the people here. It's about the people who can't enter the premises of this institution. We have to stand up for them. I would just like to, in my closing line, I would just like to say that I don't know how many of you were able to appreciate the story that I had presented at the very outset. But in my opinion, and you can search this article, just go on your laptop and search this article, Are Laws Really Made Public? In which I have just tried to explain that though primary legal authorities, constitutions, statutes, government notifications are available for free and open access, the technical know-how to interpret those laws is lacking even in the most elite students of this country. So we have experts who will allow you, who will enable you to write those research papers, who will inform public knowledge. That's your prerogative, and we will help you do that. Thank you so much. Just one small announcement.